Okay, welcome to everyone to this webinar on the Unified Patent System. And wherever you are in the world, good morning, good evening, konbanwa und vanshang hao. Thank you for giving up your time for this today, and I hope it's hopefully useful for you all. If anyone has any questions as we go along, then please feel free to type them into the chat function, and I'll do my best to answer them all at the end. Alternatively, of course, anyone can contact me by email after the webinar. So what I'm going to do is go over all of the important things that you need to be aware of for the new Unified Patent System. Firstly, what a Unified Patent is, what the Unified Patent Court is, when it all starts, which countries are involved, what changes it will bring, and the advantages and the disadvantages of the system, which will weigh into the decisions which will need to be made going forward for patent portfolios. So first of all, what is a unitary patent? Well, a unitary patent, or alternatively a European patent with unitary effect, is a new European patent right that has unitary effect in all of the states participating in the Unified Patent System. And it comes into being when unitary effect is requested for a granted European patent. As with European community trademarks and designs, a unitary patent will be a single right across all of the participating states. It will not be possible to abandon the unitary patent in some states only, as you can currently do with a bundle type European patent. And it cannot be owned by different parties in different states, although it can be licensed for individual states and to different licensees. It will operate alongside the current European patent system. It won't replace it. It will be possible to get currently unitary patent protection in 17 EU member states by submitting a single request for a unitary patent to the EPO. Now, the system has its disadvantages, advantages and disadvantages, which I'll get into a bit later. So because of these, the system may be appealing to some and not to others. And also, not all patents within an individual patents and applications within an individual patentee's portfolio may be suitable for this system. However, whether or not you should have a unitary patent is optional. Now, the Unified Patent Court is essentially an international court which has been set up by the participating states to deal with enforcement and validity issues of unitary patents and European patents. It has exclusive jurisdiction over unitary patents and also some jurisdiction over European patents within the UPC system. So the rulings laid down by the UPC apply only in the UPC participating states. Now, the intention behind the Unified Patent Court was to end the need for expensive litigation in courts in different countries, and also to try and enhance legal certainty via establishing some harmonized case law across Europe. The procedural aspects of the proceedings before the UPC is an entirely separate seminar on its own, so I won't go into any of that here. The structure of the Unified Patent Court, there is a court of first instance, which is divided into a large number of local, regional, and central divisions spread out across Europe. Where the cases are heard before the UPC depends on the technical subject matter involved and also other provisions of the UPC, such as the country where the defendant is based or a country where any alleged infringement has taken place. The central divisions are to be located in Paris and Munich, plus a third city which is yet to be selected. It was to be London before the UK pulled out of the unified patent system, but it's quite widely expected to be Milan that will be chosen. And the Court of Appeal of the UPC is to be located in Luxembourg. In terms of which countries, yes, when will it start? It's expected to start between November 22 and February 2023. The actual date itself won't be known until the preparatory period is complete. Now, this preparatory period began in January 2022 and is estimated to last between 6 to 10 months. At the end of this period, Germany will deposit the final instrument of ratification, and the UPC system will then begin on the first day of the 4th month after this date. And this deposit by Germany will also trigger what they're calling the sunrise period ahead of the official start of the UPC, and I'll explain what that means in a minute. In terms of the countries which are involved, there are currently 16 countries which have fully ratified the UPC agreement, and these are the ones coloured in light green on the map. Germany will make it 17 once they ratify at the end of the preparatory period. There are a further 7 countries, which are Cyprus, Czechia, Greece, Hungary, Ireland, Romania, and Slovakia, which have signed the agreement but not yet ratified it. If these countries don't ratify before the UPC begins, then the UPC will have no jurisdiction until the ratification, and unitary patents granted before ratification will not have any effect in those countries. As new countries do join the UPC over time, they will automatically be included in any unitary patents that are pursued after they join. But the territory covered by unitary patent is set at the grant date. So individual unitary patents will not expand in coverage as new territories join. Countries which are not participating in the UPC are the non-EU EP states, Iceland, Norway, Turkey, Switzerland, Serbia, Albania, Macedonia, and the UK, and 3 EU states, which are in blue, which is Spain, Poland, and Croatia. Now, the current system of European patents, many of you will obviously be familiar with. It's a centralized grant procedure at the EPO, which can cover 38 contracting states, plus other extension states and other validation states. After the grant, the European patent is divided into a bundle of national patents, which are then individually validated, and have individual renewal fees and individual enforcements before national courts. Now, this can be very expensive, with a lot of separate costs for different validations, with separate translations and separate renewals, as well as potentially separate litigations over different countries. In terms of what will change with the EPC, it's only the post-grant procedures which will change. The application procedure carried out by the EPO pre-grant is unchanged. Then after grant, a patentee can choose for the European patent to become a unitary patent. If the unitary patent is chosen, the owner of the unitary patent will have the ability to centrally enforce the unitary patent across all participating states. And on the other hand, third parties will be able to attack a unitary patent across all participating states in a single action. It will be possible to validate a unitary patent in all of the participating states just by submitting one translation of the whole specification and paying a single fee to the EPO. So for patents granted in English, the translation can be into any other official EU language. If the patent is granted in French or German, the translation has to be in English. The renewal fees have been set at an amount which is round about the combined renewal fees of the 4 UPC states where European patents were most validated as of 2015, when the fee was originally set. And this is paid in a single fee to the EPO. So this may make costs more attractive to patentees who validate in many European states, but on the other hand, may make a unitary patent less attractive for patentees who may only want to validate in, for example, the UK, France, and Germany, especially as a unitary patent will not cover the UK anymore. For countries which are not within the UPC system, validations and renewals will continue exactly as they have before. The existing 9-month opposition period before the EPO still remains, but any pending opposition proceedings before the EPO do not necessarily prevent a second attack against a patent before the UPC. Importantly, however, existing European patents and applications and those which are granted in the coming years will automatically fall under the dual jurisdiction of the Unified Patent Court and also the national courts, unless they are opted out of the EPC system completely, which is possible. So what you need to do is to consider whether opting out of the system or staying in the system is more suitable for your patents and applications. As I said before, what suits one patentee or even individual patents and applications within a single portfolio may not work for another. But unitary patents cannot be opted out of the system. They are locked in. So in terms of opting out of the UPC system, you basically have 3 options of what to do. First option, do nothing at all. So the default position is that everything falls within the UPC system. So if you do nothing, everything will be within the system. This option allows you to start sort of any enforcement actions early and potentially also shape some early case law, but could be risky for sort of high value patents or any patents which may be perceived as a bit weaker, which would be open to a central attack and revocation over all of the UPC states within a single action. Option 2 would be to just opt everything out of the UPC. So then there could be no central attack against any of those patents or applications, and it allows you to see how the system works initially before actually deciding to whether you want to use it or not. Or 3, decide simply on a case-by-case basis. So this will enable you to opt out any weaker or important patents while potentially leaving in stronger patents or less important ones to get some experience of how the new system works with a reasonably low degree of risk. For the opt-out, there is no official fee. the opt-out will last for the entire lifetime of the patent, unless the opt-out is withdrawn, which is possible. You can withdraw the opt-out and opt the patent back into the UPC as long as there is no ongoing national litigation involving the patent. But to opt back in is a one-way ticket. You're not allowed then to opt back out a second time. And certain rules have been laid down in that if a patent has been litigated in the UPC, it cannot later be opted out. And if any designated state of an opted out European patent is litigated before national courts, it cannot then be opted back in at a later date. So essentially, if you have a reasonable degree of doubt about using the system, it seems like the sensible option to take would be to opt everything out at first, see how things go, and then there is always the option to opt the patents or applications back in again at a later date. As I mentioned before, the sunrise period is the 3 to 4 month period between Germany's ratification of the system and the actual start of the EPC. It will be possible for patentees and applicants to opt out any granted patents or any applications from the UPC in this period, and before any central proceedings can be started against them. And this is the only way to absolutely guarantee that there will be no central attack against any of those patents. Once the UPC starts, proceedings can be initiated from the first day. So if you do decide to opt out of the system, it's best to do it during this free period. Now that it's been decided that there's going to be a transitional period for the start of the UPC to see how it goes. And this is the period within which opt-outs can be filed. Once this transitional period ends, opting out of the system will no longer be possible. It's been decided that the transitional period is going to last for 7 years, and towards the end of that, it will be reviewed, and it may be extended for a further 7 years. Now, during this transitional period, it will, for patents within the UPC system which have not been made into unitary patents, there will be the choice of whether to bring actions before the UPC or before a national court. You can bring them before either. The unitary patents themselves, all proceedings have to be before the Unified Patent Court. They cannot be opted out, and actions cannot be brought before a national court, even during the transitional period. After the transitional period ends, whenever that is, all patents and applications which are in the UPC system must be litigated before the UPC. And this will be the same for all new applications which are filed after the transitional period ends. So the only way really then to avoid the UPC's jurisdiction after the transitional period ends would be to file national applications in those states. I mean, you could obviously still get a European patent for the states which are not part of the UPC, but for the UPC states themselves, national applications would be the only way to avoid the UPC. So for your applications and your patents, you will need to decide which option suits them best. So whether to have a unified patent for them or a regular bundle European patent covering those states. And if you choose to go for a regular bundle patent, whether that should be inside the inside the UPC system or opted out. So as I've said, for any opting out, it would be ideal to do this during the sunrise period. Strategically, some patents and applications will be better off within the UPC system, while others will be better served staying out. So within a single portfolio, you could have unitary patents covering all of the participating states, normal European patents which have been opted in, which can be litigated before national courts or the UPC, or European patents which have been opted out of the system, which can only be litigated before national courts. Which of these will work best for you and for each patent and application is what rights holders will need to decide. As I've said, the default position is that everything is opted into the system. So if you do want to opt out for current European patents or for pending applications, you can simply file an opt-out request. For pending applications, you can file it while the application is pending, and the opt-out will apply to the granted patent, and you then validate it as you would a normal European patent. If you want to request a unitary patent, unfortunately, current European patents are not able to be converted into unitary patents. But for pending applications, once they are granted, you file a request for a unitary patent within 1 month of the publication of the mention of grant, and simultaneously file a translation into another EU language. So, and pending applications which are soon to be granted falls into the same category. After the 1 month deadline, it will not be possible to then retroactively get unitary effect for that patent. So that is an absolute deadline. The EPO is, however, introducing some transitional measures to help applicants who do want to have a unitary patent. It will be possible to request the EPO to delay grants until after the UPC starts. Now, this provision will only be available from Germany's ratification, and it will only apply where the notification of intention to grant has been issued and the text has not yet been approved by the patentee. However, you must still, this request in itself does not actually constitute a request for a unitary patent. You've still got to file the request for the unitary patent within 1 month of the publication of mention of grant and file the translation into another EU language. And also, this delay has no effect on the normal 4-month deadline for responding to the notification of intention to grant. So you still have to file the translations of the claims into French and German and pay the grant fees by the usual 4-month deadline. So you can also file an early request for unitary patent if the 4-month response date for the notification of intention to grant falls on or after the date of the start of the UPC. And this will come into effect upon grant. But this request can only be filed once Germany has ratified the UPC. So for any European patents which are being granted now, these will still need to be validated as normal. However, if you have any applications which are approaching grant or in which a notification of intention to grant has already been issued recently, and if you would actually like that patent to be a unitary patent, then it would be possible potentially to delay the grant by, for example, filing some minor claim amendments, which the EPO would then have to examine, and just to delay the proceedings a few months, so you can take advantage of these EPO provisions. As I mentioned earlier, there are a number of advantages and disadvantages of the UPC system, and these are all factors which will need to be considered when deciding whether or not to opt in or opt out. Now, advantages which apply to unitary patents themselves, it will be a single right covering currently 17 states. The grant costs will be lower. Only one translation is required rather than potentially multiple translations for different national validations in countries which are outside the London Agreement arrangement for translations. The renewal fees are potentially lower. Renewal fees for effectively 4 countries gives protection over all of the participating states. And the formal procedures are a lot simpler. You have one central renewal fee and one centralized assignment and license recordal arrangement. Advantages which apply both to unitary patents and to normal European patents which are opted in to the system. You can have enforcement of a patent, an ability to obtain an injunction across all of the 17 UPC states in a single action before the Unified Patent Court. The court costs are lower at the UPC than at national courts. The court fees will be set as fixed fees. Currently, they're set for an infringement action at €11,000, for revocations at 20,000, with additional value-based fees on cases worth more than €500,000. The proceedings are intended to be faster. The intended target for conclusion of first instance proceedings is 12 months before the UPC, which is faster than proceedings before many national courts and also faster than EPO oppositions. And the winning parties in proceedings are to receive reasonable legal costs and expenses from the losing party up to a set limit. And this, I understand this is going to be €38,000 for proceedings which are valued up to €250,000 and up to €2 million for proceedings with a value above 50 million. On the other hand, there are potential disadvantages depending how you look at it. Now, those which apply to a unitary patent only, it does not cover all of the states which you might necessarily want to be covered by a European patent. So separate validations will likely still be required. Certainly, if you want to have coverage in the UK or Spain, then those will not be covered by a unified patent. The translation costs are potentially higher for those patentees who would normally only validate in a few countries under the London Agreement, which don't require translations. So again, if you would normally validate in the UK, France, and Germany, where there are no translation requirements, then actually doing a translation of the entire specification will add some costs. if only one or two or three UPC states would be required for a patentee, the renewal fees, which is set at the total for 4 countries, would be higher. And the renewal fees are fixed at this amount. So you are not able to reduce your outgoing costs by dropping individual designations as you currently can do with the European patent. In terms of one's disadvantages, which apply to both unitary patents and European patents within the UPC system, you have potential essential revocation of patents across all of the states in a single action. So rather than taking a number of actions before national courts for total revocation of an action previously, revocation of a patent previously, it could now be done in one single action before the UPC. There is obviously a little uncertainty in terms of how the UPC will function and the initial quality of the decision. I mean, the UPC has said that they're hiring extremely competent judges and that they don't expect the decisions to be of a poor quality, but until we see these decisions, there's always going to be a degree of uncertainty. On the other side of one of the advantages, the losing parties, any proceedings have to pay those reasonable legal costs and expenses to the winning party. And there is the possibility of bifurcation of proceedings for infringement and validity, although this in practice should hopefully be unlikely. So what factors do you need to consider when you're choosing whether to go for a unitary patent or to opt in to the UPC system and then therefore be subject to jurisdiction of the Unified Patent Court, or to stay out of it? Now, amongst the main things to consider are, firstly, the strength of the patents themselves. Obviously, a weaker patent will be more vulnerable to challenge and to central attack. So, and not having it exposed to central attack and potential central revocation would be a preferable option. So this could apply, for example, to patents where the granted claims in Europe are quite broad, especially if they are broader than other related cases due to prior art, which was not considered by the EPO. So such patents may be better off opted out of the system. On the other hand, a patent which is perceived to be quite strong and should be more robust under challenge, would receive less of a threat from the UPC, and the ability to enforce it throughout Europe in a single action could be preferable. The value of the technology itself and the value of the patent to the business, it would likely be preferable to shield patents which are highly valuable to the business from a central attack at the UPC. So any challenges would have to be done before the national courts in each of the validated states. Ideally, you should link the patents to their commercial products and assess the importance of those products to the business. And for example, if any particular patent covers a successful product or is bringing in revenue via the patent box system, then you may wish to opt it out of the system. The likelihood of enforcement, if you were anticipating enforcing a patent in different countries, then central proceedings would be rather more cost effective, and so remaining in or opting back in may be the preferable option. Alternatively, if the likelihood of a challenge to the patent is considered to be quite high, then you may wish to opt those patents out. to avoid the central attack. If the likelihood of attack is considered to be low, on the other hand, then you may not be as inclined to opt it out. And of course, costs, which is an important consideration in any of these. It comes down largely to where do you want to validate the patents? Where do you want the protection? If it would only be in a low number of countries, such as the UK, France, and Germany, then the EPC would not really be cost effective, especially with the system not covering the UK. But alternatively, if you want coverage across a larger number of countries, then the EPC system would be more cost effective with the single translation and the renewal fees of only 4 countries covering, giving protection for at least 17. Now, this graph shows sort of estimated cost differences of validating in different countries compared with having a unitary patent over different durations of the patent. The left-hand column is for validations only in Germany, France, and Italy, and compare that with a unitary patent, that would be a lot cheaper than having a unitary patent, up to 42% cheaper over different periods of the life of the patent. However, as you add more countries, so Holland and then Austria and then Belgium and then all of the unified patent states, the costs over the lifetime of the patent would be significantly increased, up to 84% increase potentially in over the years that the patent is maintained in those countries. So if you're going to validate it in a number of states and maintain the patent over a longer period, then the unified patent system is significantly more cost effective. But for a lower number of states, only 3, then opting out would be more cost effective. There are a couple of other considerations as well that should just be borne in mind. While a patentee can start infringement proceedings before the UPC and aim for a central injunction over all of these states, this obviously opens the patent up to a central invalidity attack and potential revocation across all of these states, as well as non-infringement counterclaims. So that is kind of a double-edged sword. And it would also be tactically possible for competitors to trap patents or applications which have been opted out of the system by initiating lawsuits in national courts, as it will then not be possible to opt them back into the system. In terms of who is able to actually file the opt-out request, if this is what you want to do, it must be the actual rights owner or an appointed representative. If the representative is to do it, then they will require a signed authorization from the owner. If there is more than one rights owner, one patentee or applicant, permission will be required from all of them. So the opt-outs, the requests will not be checked to determine whether or not all the true owners have agreed to an opt-out, or if there are any other flaws in the opt-out request, but incorrect opt-outs can potentially be challenged and invalidated, which would then still leave them open to proceedings before the UPC. If the actual owner or owners in respect of any of the states differs from the registered proprietor on the EPO register, parties filing the request will need to be able to demonstrate a chain of title from the original or registered rights holder to themselves. So in order to try and rebut any challenge to the validity of the opt-out request, if you're not able to prove a chain of title and that you are not, in fact, the legal rights owner, then the opt-out could be potentially invalidated. Opt-out requests are to be filed using a UPC case management system. You don't file them at the EPO. And the opt-outs, as currently anyway, must be in relation to specifically named European patents or applications. It's not currently possible to do a broad opt-out, for example, to opt out all European patent applications in the name of a particular patentee or applicant. Although it is said that a single request identifying and opting out more than one patent or application will be possible. And it will also be possible to view the database of opted out patents and applications to check the opted in or out status. So, and presumably in time, it will be possible to view entire portfolios of competitors and the statuses of their patents, and potentially being able to see sort of the opted in or opted out strategies of competitors might provide you with some interesting insights into their priorities, tactics. Some other issues to consider in terms of the EPC, joint ownership, I've just said you need consent from all co-owners to opt out. So any current collaboration agreements will define which party has the right to direct patent prosecution and commence infringement proceedings. It's, however, unlikely that existing agreements will contain any clauses relating to the UPC. So patentees with joint owned cases will need to get the consent of all of the other co-owners, and time will probably be needed to do this. It's also a good idea for all such future collaboration agreements to include clauses which do relate to the UPC. So you can include clauses which automatically sort of grant permission for opting in or opting out or control over these proceedings. It can matter which co-owner is named first on the patent if they are of different nationalities of UPC states or have different places of business within UPC states. So if a patent is litigated before the UPC, the order of the name of the patentees or the applicants will dictate the law, that will dictate the national law of the court used in relation to certain issues. And if there's no owners within the participating states, then German law applies. Exclusive licensees and non-exclusive licensees will not be able to apply for any opt-out of any patent they license. That's not entirely surprising. However, there are some issues which a licensor will need to be wary of and address with their licensees. So any new licenses will ideally need to be drafted so they make clear who has control of any potential litigation strategies and who is responsible for costs. For example, if a patent is exclusively licensed to different companies in different countries within the UPC system, each licensee would likely have the right to bring infringement proceedings in their respective countries under the terms of the license agreement. If the patent is not opted out of the UPC system, then one licensee could potentially initiate infringement proceedings before the UPC and thus block an opt-out before any opt-out is registered, as well as provoke a central revocation act counterclaim before the UPC, which could potentially lead to loss of patent rights across all of the UPC states, which would then obviously lose rights for the other licensees in the other countries. On the other hand, if a patent is opted out, one licensee could initiate infringement proceedings before the national courts and therefore prevent the patent from ever being opted in. So some central control of the licensee's ability to litigate would be required to avoid these sort of situations. In terms of future filing strategies, in the short term, while the transitional period is in effect, then it can largely go on as it is now, and you can opt out of the system. However, once the transitional period has ended, then you may need a mixture of European and national applications to cover the countries that you want if the UPC is not an attractive proposition and you want to stay away from the jurisdiction of the UPC. You can file European applications which cover all countries which are not within the UPC system, but for the countries which are in it, then national applications would be the only way of avoiding it. For UK-based patentees, it could be potentially useful that the UK has withdrawn, given that you can have a home market UK patent lying outside the UPC, in addition to a unified patent covering many of the other states. So your home market UK patent would be safe from any central attack. And in terms of monitoring competitor patents, if you know of a competitor patent which is relevant to you, you can monitor whether or not it is opted out, and then consider initiating some central revocation proceedings before they are able to opt out. And finally, this slide has some links to useful information regarding and resources on the UPC. We'll be sending copies of these slides out to everyone after the webinar, so you'll be able to look at these at your own leisure. So I hope this webinar has been useful for you all. And if there are any questions, either now in the chat, I shall have a look, or as I said earlier, if you want to send me an email afterwards, I'll be more than happy to answer it. And as I said earlier, we don't know yet exactly when the UPC is going to start. I've not heard anything or any update as to when the preparatory period might finish. So it could be any time between July and November. But as soon as it does, then we will know the actual start date of the UPC, and we'll update you all with that information. at that time. And then that point we will know when the sunrise period starts and when you can start to opt out any patents and applications that you don't want to be part of this system. I would expect as well the 7 countries which have ratified, which have signed it, the agreement, which have not ratified it, probably wouldn't be too long into the system before they do, as long as it all goes smoothly at the outset. So you'll then have potential protection in 24 countries, or 1 translation and one renewal fee. So that potentially makes the system quite attractive from a cost perspective and a coverage perspective. It's just weighing that up against the potential risk of central attack. There's a few comments in the chat, but no questions as yet. So if no one else has any questions, I'll wrap it up in a minute. As I said, by all means, feel free to drop me an email and I'll do my best to answer it. Because as you can see from the last hour of me talking, it's not an entirely kind of straightforward and black and white system. There are plenty of things to consider as to whether you want to opt in and opt out, or to go actually for a unitary patent itself. Okay, yeah. So we've got no questions. So I'll finish here. I'll wish you all a good day or good evening, and I'll hopefully hear from you all soon. Thanks a lot.